Thank you very much. Good evening to everyone. It's very tough to be the last speaker of a very exciting day, but in a way I'm very glad that my presentation comes after Eve's because I think it will also provide a view of what a country of origin also does in terms of its legislations and in terms of its programs and services concerning the return and reintegration of their nationals based abroad, including those that have been trafficked, and particularly those that have been trafficked. Okay. This year marks the 15th anniversary of the adoption of the Palermo Protocol, and if we look at what has happened since then, it's probably a case of seeing the situation as the glass being half full and the glass being half empty. On one side of the argument, it can be said that many initiatives have been implemented in order to promote the so-called 3 Ps, prevention, protection, and prosecution. But then on the other hand, we can also say that probably the glass is half empty, especially if the measure of things would be the protection of victims, and especially protection that is very meaningful to them. So in this discussion, the return and reintegration programs for trafficked persons, of course, are very important because they are key to the transformation of victims of trafficking into survivors. And in some sectors, they would even add also survivors becoming thrivers in the process. There had been some general observations that had been made about return and reintegration programs for trafficked persons, and they all point to the fact that it's from one of the studies, they concluded that this particular aspect has been understudied, under-theorized, and is a low priority for most donors. And the most recent Global Slavery Index report also came to the same conclusion, that if ever there are programs and services for trafficked victims, mostly they are of short-term assistance, and they are very much focused on women and children. So I will focus on the Philippine experience, and perhaps the Philippine experience can be quite instructive because it is a country that has experienced large-scale and intense out-migration in the last 40 years, and it has also a range of programs and services as well as legislations for the protection of migrant workers and people who had been trafficked. And my presentation has a twofold objective. First of all, I'd like to discuss the legal, institutional, and policy framework of return and reintegration interventions. And the second objective will be to examine how stakeholders assess the country's response to the return and reintegration of victim survivors of trafficking. And the presentation will follow the objectives. First, to set the scene, there is an estimated 10.5 million overseas Filipinos. This is the stock estimate as of December 2012. It is a figure that is not necessarily problematic. In fact, we also raise a lot of issues about the methodological basis for coming up with this stock estimate, but nonetheless, it is the only one that's available, and so we often use it as a point of reference. You can see from the statistics that there are 3 categories of international migrants that are part of this stock estimate. There's the 4.9 million permanent settlers, and then 4.2 million temporary migrants. Most of them are overseas Filipino workers. And then there's the count of 1.3 million who are in an irregular situation. It's not very clear how, whether, and to what extent could be the number or estimate of trafficked persons within the larger category of 1.3 million migrants in an irregular situation. Nonetheless, there are many reasons and also a lot of concerns in the Philippines about the possibility that the numbers could be substantial. That is, the number of trafficking victims could be substantial because the conditions of international migration from the Philippines seem to have some conditions that put people at risk to trafficking. And what are some of these conditions? First of all, there's the large numbers that are in less skilled occupations or perhaps what Beata has mentioned, people who are working in the informal economy. And a cause for concern is the very large share of migrant workers who leave for domestic work. And of course, because of the nature of domestic work, a large proportion of this consists of women. And in the Philippines, women are a significant component, not only in terms of labor migration, but also because of their participation in international marriages. International marriage has become a very significant phenomenon in East Asian countries, notably Japan, Taiwan, and South Korea. And there have always been some concerns that international marriage would involve some form of trafficking. And then, of course, there's the real concern that when you look at the conditions in the countries where they work, protection is not necessarily a priority of the destination country. Within the Asian context, labor migration is actually regulated, but the regulation is limited to the regulation of the migration movement, the migratory movement, that they are legally deployed from the countries of origin, that they legally enter the countries of destination as workers for specific occupations, but these are not government-to-government arrangements for the most part. And in fact, the recruitment of workers rests largely in the recruitment industry. The recruitment industry would involve players that are legally licensed recruitment agencies, but it doesn't necessarily mean that legally licensed agencies do not commit irregularities. And in addition to the legal ones, there are other actors that have varying legalities, including traffickers and smugglers in this whole scheme of things. And it is, in fact, the participation of the recruitment industry that has introduced a lot of problems because, of course, when they play a mediating role in labor migration, they exact fees. And even if governments like the Philippines have a ceiling on what could be legal placement fees, this is also routinely violated. And when you look at the labor migration cycle, when something goes wrong at the recruitment phase, then it could have a lot of implications for the protection of workers down the line. When we come to trying to establish an estimate of how many people are trafficked from the Philippines, again, this is really very difficult. It's very difficult to establish the magnitude of trafficking from the Philippines. As I had mentioned earlier, we have a stock estimate of Filipinos in an irregular situation overseas, but it's not very clear how much of that particular number would be attributable to trafficking. The anti-trafficking law of 2003 provides for the establishment of the Philippine Anti-Trafficking Database, and there's supposed to be two components of that particular database. One is to have data on convictions, which is under the Department of Justice, and then the other one is to have the National Recovery and Reintegration Database, which was implemented only in 2010. And in fact, the establishment of a national referral system and the accompanying National Recovery and Reintegration Database was done with support from the ILO. Another source of data would be the number of calls that are received and by the so-called 1343 action line, which has been implemented since 2011. And as you can see, some of these data sources are under the responsibility of different government agencies. They don't really provide us a very good picture of the numbers that are involved, as well as the profiles and patterns of trafficking. And it's difficult sometimes to reconcile, the one data source from another. But nonetheless, for instance, if we look at the number of convictions since 2005, the Department of Justice reports that there had been 180 convictions involving 202 traffickers since 2005 up to 2014. If we look at the number and profile of trafficked persons assisted by the Department of Social Welfare and Development, we can see that as of 2014, there were about 2,000 persons that they had provided assistance to. And if we look at the data coming from the 1343 action line, since 2011, they had received more than 17,000 calls. And these are not necessarily calls for assistance. Some of them could be simply calls for calls that require or ask assistance for information, but nonetheless, they were able to capture more than 200 cases for further follow-up, out of which 70 were cases of trafficking. So in a sense, the numbers may not be that much, but when we talk about the issue of human trafficking, it's not really the numbers that count so much as the fact that people's rights are very much violated. When we turn to the patterns and profile of trafficked persons based on these different data sources, the patterns and profile hew very closely to the data that was presented by UNODC and also ILO. So, for instance, men and women are trafficked, but there's still the pattern of women outnumbering men in this particular phenomenon. And in terms of age, based on data from the National Recovery Database, the largest group are those in the ages 18 to 30 years old. And it's important to highlight here that minors comprise 17% of those that had been trafficked. Note that the NRRD database refers specifically to those that are internally trafficked. And so we also see here the reality of minors that are quite an important component of internal trafficking. And again, we also see some kind of a divergence that when it comes to male victims, it's mostly forced labor, while in the case of female victims, it is largely sex trafficking. For calls that were received by the 1343 hotline, they confirmed that there are more cases of internal trafficking than cross-border ones. And of those that had been trafficked overseas, the most number of cases happened in Saudi Arabia and Malaysia. Okay. So what have been the actions taken by the Philippine government? The Philippine government was one of those that ratified the Palermo Protocol early on, and it enacted the anti-trafficking law in 2003. And it came up with an amended, or what is called as the expanded anti-trafficking law in 2012. What are some of the provisions of the expanded anti-trafficking law? It strengthened the Interagency Council, the IACAT, as we call it in the Philippines, which is the body that is responsible for the formulation of policies and the coordination of different anti-trafficking initiatives in the country. What is also quite important in the expanded anti-trafficking law is that it included not just penalties and sanctions against trafficking, but also attempted trafficking. In other words, once trafficking has been initiated, even if it did not become very successful, there can be penalties and sanctions that could be attached to that. And the Philippines has also participated very actively in bilateral, regional, and international actions concerning this particular topic. It's interesting to note also that there had been some external assessment that have been conducted by various bodies, and they show they have a different appreciation of what the Philippines has done in terms of anti-trafficking initiatives. For example, when we consider the U.S. Trafficking in Persons report, which has been available since 2001, the Philippines largely falls in Tier 2. And there were some years when the Philippines slid into the very dangerous Tier 2 watch list. And in a summary observation of this different trafficking in persons report would suggest that the Philippines has always been ranked consistently as being very weak in terms of prosecution. Okay? When we consider another source, the 3P Index, which has been available since 2000, their most recent assessment in 2014 would show, they rank the Philippines as being weak in protection. And And then the most recent one, the Global Slavery Index, which has been available since 2013, has an estimate of some 261,200 Filipinos in modern slavery. And it ranks the Philippines as 29th and 19th in terms of prevalence and absolute number relative to 167 countries. Interestingly, it cites the Philippines as having done quite a lot for its criminal justice response despite having limited resources. And it ranks the country rather positively and rather quite high, ranking next after Australia and New Zealand when the context of the comparison is the Asia-Pacific region. Okay. Now, the national legislations regarding return and reintegration are provided in two important laws. The first one is the Migrant Workers and Overseas Filipinos Act of 1995, which is quite a pioneering piece of legislation, particularly in the Asia-Pacific. It's probably the first, the Philippines was probably the first country to have a specific law whose intent and whose objective is to promote the protection of migrant workers. This was amended in 2010, the so-called Republic Act, or RA 122. I guess to summarize the feature of this particular law is that it offers a very comprehensive approach of protecting migrant workers at 3 points, 3 important moments of the migration cycle: before they leave the country. And so for this phase, you have a lot of preventive mechanisms, including the training of workers, including having the pre-departure orientation seminars, so that workers would be able to anticipate what it is that they are likely to experience once they are already in the countries of destination. And of course, there's also the provision for return. I have to highlight that there is a provision for return because labor migration in Asia is supposed to be temporary. Okay? When the Philippines started deploying workers in the 1970s, it was thought to be just a temporary measure. But now it has become permanently temporary. Okay? If you are in less skilled occupations, even if you have worked for a decade in countries like Saudi Arabia, if you are a domestic worker, you cannot have citizenship. You cannot have permanent residence. Okay? Now, of course, there are very specific provisions about return and reintegration in the anti-trafficking law, and as it was amended in 2012. So what are the key provisions? So I just summarized the points here. First of all, let's take the key provisions from the Migrant Workers Act. I think it is important to have a comprehensive view of, because the way that I approach this particular topic is to consider the issue of trafficking in persons in the larger canvas of international migrations, the diverse international migrations from the Philippines. From the Migrant Workers Act and in its amended version, let me start first with on-site services and programs. Note that this is the Migrant Workers Act and it was not really that sensitive yet, even the amended version, to trafficking in persons. Okay? So there are provisions pertaining to the assistance to both legal and irregular migrant workers. In fact, before the Migrant Workers Act of 1995, way back in 1991, there was already the Foreign Service Act of 1991, which requires foreign service posts to provide assistance to overseas Filipino nationals, regardless of their legal status in the countries of destination. So this was really a landmark philosophy, and it is also the same act that enshrines the protection of overseas Filipinos as the third pillar of foreign policy in the Philippines, suggesting the significance and importance of international migration, particularly international labor migration to the country. So first, there are on-site services and programs to distressed workers, which could include trafficked persons. What are these? They could have access to the Migrant Workers and Overseas Filipino Workers Center. Among others, these centers also provide shelter services. Okay? And part also of the institutions that are exported to countries of destination are the so-called Philippine Overseas Labor Offices, where there are labor attachés, there are welfare officers, and in a few cases also social welfare attachés, which are deployed by the Department of Social Welfare and Development. And they take care of different aspects. The labor attachés with labor questions, welfare officers with personal problems, emotional problems, or maybe issues dealing with the families left back in the Philippines. And because there are different agencies where these different personnel come from, the law also provides for the so-called country team approach, so that all the various activities and all the various personnel could be coordinated by the work of the ambassador, under the leadership of the ambassador or the consul. So it's very easy, therefore, to coordinate with the relevant home agencies when you have also these different offices that are based abroad. With regards to repatriation, there is mandatory repatriation of underage workers. For the most part, this means workers below 18 years of age, or for certain occupations, like in the case of domestic work, they have to be at least 23 years old before they can be legally allowed to work as domestic workers overseas. And the law also provides for the establishment of the National Reintegration Center for OFWs. They have, on the one hand, continued to provide welfare programs for distressed returnees, which could include trafficked persons, as well as developmental programs for the more successful ones, like if they want to establish a business or if they want to participate in some brain gain activities in the country. From the Anti-Trafficking Act of 2003, there are some provisions concerning services to trafficked persons, and they are enumerated there. It includes emergency shelter or appropriate housing, counseling, legal services, and so forth. And interestingly, the provision does include follow-up and monitoring of trafficked persons. And then there are services to trafficked persons overseas, which are compatible with what has been provided by the Migrant Workers Act. And then there's the Department of Social Welfare and Development in the amended law is mandated to implement rehabilitative and protective programs for trafficked persons, including the accreditation of NGO partners in the provision of direct services and assistance. So a key issue, therefore, especially coming from overseas, is the identification of trafficked victims, because so far, when you consider the Migrant Workers Act, they are considered under the large rubric of workers in distress. Okay, so this is just to show that the Interagency Council Against Trafficking in Persons is replicated at different levels, from the national levels down to the regional, the provincial, and the city and municipality levels. The idea of the Interagency Council Against Trafficking, especially if you start from the national framework, is that it consists of 9 agencies. And the 2 key agencies are the Department of Justice, and then the Department of Social Welfare and Development, which, as has been mentioned earlier, is the one responsible for taking care of the rehabilitation of trafficked victims. This one, sorry, the print is very small, but it does try to summarize the different flow charts that had been developed by different government agencies in how they are to respond to calls for assistance. And from the time that they receive a call or there is a referral for a certain person, there are flow charts that are developed by the different government agencies on where to go for specific types of assistance. Okay. So those are the laws, those are the flow charts, but how does it work in real life? So for this part of the paper, I tried to do some key informant interviews with a number of stakeholders, 7 key informant interviews from the DSWD, some civil society organizations, including a faith-based organization. And their consensus is that there is a need to expand and improve return and reintegration programs for trafficked persons. Actually, most of the observations here are quite similar to what has been mentioned by Yves earlier. Okay? So according to DSWD, the approach is the same whether it is cross-border or internal trafficking. Okay? So you just have a layer of dealing with the Department of Foreign Affairs and the Department of Labor and Employment when it comes to overseas trafficked victims. But then the rest would, the rest of the flow chart would be quite the same. And indeed, the assistance that is provided by DSWD to trafficked persons is largely short-term. About 40% are psychosocial counseling. And if you look at livelihood assistance, it's a very, very small proportion of the total share of assistance provided. What is also quite problematic about the DSW shelters is that it's not specific to victims of trafficking, but the shelters that they operate also provide care to other victims of abuse. Okay, so this can provide problems also in terms of the services that are provided to trafficked victims. And of course, there's always the problem of overcrowding and understaffing. Okay, like in one shelter, it is said that the ratio of the social welfare officer to the person staying in the shelter is 1:40. So that is quite a lot. No? And then there's also the issue of the trafficked victims. When they are rescued and they stay in the shelters, they want to run away. And the social welfare has this observation that they see the social welfare as the villain. And in fact, they have a lot more sympathy with their traffickers because they see the traffickers as providing employment for them. So this is what it is on the ground. There's also the reluctance of trafficked victims to seek assistance. No? In fact, the DSWD reported that they are not able to really use up the funds that they have for certain years because trafficked victims do not want to seek assistance, or at least they see that kind of see that kind of reticence, and they also observe that there's also those that they are trying to help may feel that they are stigmatized if they are visited by a social welfare officer, and so some of them just they are not able to follow up, and they say that they provide assistance to both trafficked men and women and both trafficked girls and boys, but programs and facilities actually for trafficked men and boys are very much lacking, especially overseas. No, the shelters for Filipino workers are mostly catering to women. No, so there was a situation when there was a recruitment of Filipino workers to work in the military installations in Iraq, and there was actually a ban from the Philippine government for workers to be deployed to Iraq. But what happened was that the workers left the country thinking and having a contract that they are going to work in Kuwait. But once they reached Kuwait, they were forced to move to the military installations in Iraq. So actually that particular case highlighted to me how things can be very fluid. From the Philippines to Kuwait, it's legal migration, legal labor migration, but from Kuwait to Iraq is a different story altogether. So when some of them were able to escape from the military installation in Iraq, they could not find housing. They could not find shelter in Kuwait, in the Philippine embassy, because it was only for women, and in any case, the shelter was also very full. So they had to, other accommodations had to be found for them. I think it was also mentioned by Yves that when we think of reintegration, it's not necessarily return to the victims' homes or our families or communities, because this is not the conditions before migration may not always be ideal. Okay, and of course there's the importance also of monitoring trafficking victims, because it's important also to identify how many had been re-trafficked. Okay. So what are some of the conclusions? In the Philippine case, we can see that both the laws on migrant worker protection and anti-trafficking provide some level of protection to trafficked victims. But it is still very important to emphasize the need to be able to identify victims of trafficking so that they could access more assistance for the kind of situation that they have faced. This would call for education programs for migrant workers. As I mentioned, there are already pre-departure orientation programs, but this can also be strengthened and be sustained by post-arrival orientation seminars, which some of the embassies are already doing. It is important for migrant workers to know conditions that may be trafficked, that will help them identify their situation if they are already facing trafficking situation. Unfortunately, even if workers are deployed legally, their legal status does not guarantee that they could be protected. Okay? Take the case of domestic workers. You leave the Philippines legally, enter Singapore legally, but once you enter Singapore and your passport is taken away from you, and you work for 15 hours in a day, and you don't have a day off, what does that mean? You were legally deployed, legally admitted, but the working and living conditions are not humane. The living and working conditions are very difficult. There's also a need to, of course, highlight, can I have just 1 minute? The training of migration-related personnel, because especially they are at the forefront, okay, when workers are overseas. And of course, recruitment agencies can also be target for education campaigns, but one of the positive signs is that also there's an emergence of discussion of ethical recruitment among the recruitment agencies. I think I would also just highlight here the need also to provide more support to local government units, because again, they are in the forefront and there is a need to coordinate what is happening and what is being decided and designed at the national framework, and what is available at the local level as well. So this would call for a lot of capacity building as well. Of course, reintegration of trafficked persons is a long-term and multidimensional process, and this would require a lot of group work, using the words of Jeffrey Sachs, and also concerted efforts and resources of different partners. And perhaps a very simple suggestion, maybe one of the future global reports could have a thematic focus on recovery, return, and reintegration initiatives, so that we could also learn from each other. So thanks very much for your kind attention.